Hello everyone. Today I will be talking about what is sedition and the latest order passed by the Supreme Court in relation to sedition. Now, when we are talking about sedition, what do we understand by sedition? What sedition literally means, we will first understand that. So, literally, sedition means any language or behavior which is intended to persuade other people to oppose their government and change it. So, something which is done by using violence, something which is done with the intention of persuading people to oppose their government, to do something that they want to change their government with their actions by using violence. Now, if we see, sedition law is not something new. It has been in existence since British time. So, the sedition law was first enacted in 17th century in England when lawmakers believed that only good opinions of the government should survive, as bad opinions which were against the government are detrimental to the government and monarchy. So, with this purpose, they came up with this law that they only want good opinions about the government and not the bad opinion. No one should go against the policies made by the government. Now, this law was originally drafted in 1837 by Thomas Macaulay, the British historian, but was inexplicably omitted when the Indian Penal Code was enacted in 1860. Section 124A was inserted in 1870 by an amendment introduced by Sir James Stephen when it felt the need for a specific section to deal with such kind of offense. So it was one of the many draconian laws enacted to stifle the voices of dissent at that particular time. So the only purpose was that any person, any group who is having opinion against the government, their opinion should be crushed, that person should be given punishment, and such an opinion should not be allowed to make voice in the society, in the community they are living, because it will be harmful for the government. Now, if we see the current law which is in existence, that is section 124A of the Indian Penal Code, what it states? It states that whoever, any person, if by words, either by speaking or by writing or by any kind of sign or symbol which is having visible representation, and the purpose of these things, the purpose of that writing, the purpose of that symbol, the purpose of that visible representation is to bring hatred in the minds of the people, or is trying to excite people, or trying to excite disaffection, dissatisfaction towards the government, which is government that is established by law in India, then such actions, such words, such visual representation by that particular person will amount to sedition. And sedition is a non-bailable offense which is punishable under section 124A, and its punishment ranges from 3 years to a life term to which fine may be added. So any person who is charged with sedition will be barred from a government job. They will have to live their life without a passport, and they must produce themselves before the court at all times whenever required. So now you can see that what all will be counted under sedition, under seditious behavior, under what all categories a person can be charged under sedition. So if you are speaking anything, if you are writing anything, if you are with the help of symbols or signs or any kind of visual representation which is affecting, which is bringing hatred in the minds of the people, or causing disaffection towards the government, then such an action will amount to sedition. Now, all of us know that sedition is not new. It is present since the British colonial time. So there were many freedom fighters, famous freedom fighters who were charged under the sedition law. Who were these famous freedom fighters? They were Mahatma Gandhi, father of the nation, Bal Gangadhar Tilak, Maulana Azad, Annie Besant, Shaukat Ali, and Muhammad Ali. Now, is this sedition law constitutional? Because we see that uh, right to freedom of speech and expression, right to freedom of, we have a freedom to express our opinion, to express our thoughts. Now, when it comes to sedition, we see that if you are saying anything, if your words, those words to which you are expressing yourself, which might lead to incitement in the public against the government, then such an expression will amount to sedition. Now, is this law constitutional? So, in a very famous case of Kedarnath Singh versus Union of India in 1962, the Supreme Court upheld the constitutional validity of Section 124A. But the Supreme Court held that unless there is incitement of violence, criticism of the government cannot be called sedition. So now in this case, what they said, that if there's only criticism involved, then it cannot be said to be sedition, because it is our right. It is our right to express ourselves, express our opinion. If we are against the policies which are drafted by the government, then we have the right to express our opinion. But if there is any incitement of violence, then it should amount to sedition. This was what was held in the case of Kedarnath Singh versus Union of India. Now we will talk about a very recent case of Vinod Dua versus Union of India, in which Vinod Dua, who was a journalist, was booked under sedition. Now in this case, it was held that activities that are intended or have the potential to cause disruption or disturbance of public peace by resorting to violence, according to the Supreme Court of India, are to be criminalized. And based on the facts of this case, the court concluded that the words used by journalist Vinod Dua may best be described as expressions of disapproval of measures taken by the government and its officials for the current crisis to be resolved swiftly and efficiently. So the words which were used by Vinod Dua in his tweet, in his YouTube video, were not created to incite others or demonstrate a proclivity for causing trouble or disturbing public peace through the use of force. So that's why Vinod Dua was acquitted and he was not charged under the offense of sedition. Now we will talk about the recent order passed by the Supreme Court in the case of S.G. Bombatkare versus Union of India and Editors Guild of India and another versus Union of India. So in this case, the Supreme Court ordered that the 152-year-old sedition law under Section 124A of the IPC, that is Indian Penal Code, should be effectively kept in abeyance till the Union government reconsiders the provision. And it also said in an interim order, the court urged the center and the state governments to refrain from registering any FIR under this Section 124A while it was under reconsideration. So a bench which comprised of CJI N.V. Ramana, Justice Suryakant and Justice Hima Kohli held that all the pending trials, appeals and proceedings with respect to charges framed under Section 124A should be kept in abeyance. And the Chief Justice of India also held that Therefore, we expect that till the re-examination of the provision is complete, it will be appropriate not to continue the usage of the aforesaid provision of law by the government. So now those who are in jail, who are booked under section 124A, can reach out to court for their bail, and also no new cases will be registered under section 124A of the Indian Penal Code. So from this order, we can see that now even the government is considering that this 152-year-old law, which was made during the British period, is no more required, and changes needs to be made, and that's what is being reconsidered by the government. So I hope this video was helpful to all of you in understanding what is sedition, what is the purpose of it, and the new order passed by the Supreme Court. In case you have any query in regard to any legal matter or law exam, you can reach out to me on my email ID or on my Instagram ID. Link for the same is provided in the description below. Thank you very much.